The International Court of Justice hereby rules that the actions constitute a breach of public international law. The judgment is final.
Imagine an assassin stands exactly 1 inch inside the border of country A. He raises a high-powered rifle, and, well, he shoots a target standing 1 inch inside the border of country B.
Oh, that's a classic setup.
Right. And then the assassin drops the gun and just walks away.
Yeah.
So who has the legal right to arrest him? I mean, is it country A where the trigger was pulled?
Or country B where the victim actually fell.
Exactly. Or, what if the victim was a citizen of country C and the assassin was from country D? Gets complicated. Welcome to the Deep Dive, everyone. Today we are tackling the invisible, honestly kind of chaotic rule book that keeps the planet from tearing itself apart. We're talking about public international law.
It really is the invisible scaffolding holding the whole global order together.
Yeah, and we aren't just skimming the headlines today. If you are preparing for a massive exam on this topic, consider this your wall-to-wall masterclass. We're going to extract every vital concept, every foundational theory, and, well, every landmark case from the source material.
And translate all of that dense legal doctrine into law purely as the body of customary and treaty rules that civilized states consider legally binding in their relations with each other.
Okay.
The absolute key takeaway from Oppenheim's traditional view is that states, and exclusively states, are the subjects of international law.
Right. So under that traditional view, an individual person, or say a massive multinational corporation, basically doesn't exist on the international legal plane.
They're invisible.
It's an exclusive VIP club, and the only members allowed inside are sovereign countries.
Exactly. But that view was violently disrupted. It ultimately became totally outdated. The modern definition, championed by scholars like J.G. Stark, recognizes a much more complex reality.
How does Stark define it?
He defines it as the body of law that states feel bound to observe, yes, but crucially, he expands the circle. It includes the rules relating to the functioning of international organizations.
Like the United Nations?
Yeah, the UN or the World Health Organization. And it also includes specific rules relating directly to individuals and non-state entities.
So why did that shift happen? What actually broke that traditional model?
Well, World War II broke it. The sheer scale of the atrocities committed during the Holocaust and the whole ensuing conflict proved that leaving human rights entirely up to individual sovereign states was just a recipe for catastrophe.
Yeah, that makes sense.
The establishment of permanent international institutions, the rise of a global human rights framework, and the desperate need to punish international crimes, like, what happened at the Nuremberg trial.
Right, they had to hold individuals accountable.
Exactly. It forced the law to evolve. The international community realized that just regulating states dealing with states wasn't enough. Individuals had to have some standing and some accountability separate from their governments.
Which brings us to a massive philosophical clash in the sources. The positivist versus the naturalist view of law. Now, John Austin is a major name here on the positivist side, and he famously claimed that international law isn't actually true law at all.
He was pretty harsh about it.
Yeah, he called it merely positive international morality. Why was he so dismissive of the whole thing?
Austin's perspective stems from his command theory of law. He argued that true law absolutely requires a sovereign commander, a political superior who issues commands to political inferiors.
Right.
And crucially, those commands must be backed by the threat of a physical sanction or punishment.
A club to hit you with if you disobey.
Basically, yeah. Because there is no global legislature, no world police force, and no ultimate sovereign reigning above the nations of the world, Austin concluded that international rules just failed the test.
Right.
For a strict positivist like him, without a commander and a club to enforce the rules, international agreements are just moral guidelines. They are polite fictions based on opinions and sentiments, not real law.
Wait, I have to push back on Austin's theory here. I mean, if international law is just morality, why do countries spend millions of dollars and decades of diplomatic effort negotiating these massive, detailed treaties?
It's a great point.
Why do they hire armies of lawyers to go to international courts? It's like saying the rules of a neighborhood watch aren't real, simply because there's no official police officer living in your spare bedroom. The community itself is the enforcement mechanism, isn't it?
That is precisely the counter-argument. And it is championed by thinkers like Sir Henry Maine and Louis Henkin. They argue vehemently that international law is true law.
What did Maine say?
So Henry Maine looked at history and pointed out that even in primitive, early human societies that lacked a central sovereign or police force, there were still rigidly binding laws based on custom.
Ah, so custom was the law.
Yeah, the community enforced them through exclusion or retaliation. And Louis Henkin took a more modern approach. He famously emphasized that almost all nations observe almost all principles of international law and fulfill their obligations almost all of the time.
That's a great quote.
For Henkin, the objective reality of compliance matters much more than the theoretical structure of a sovereign commander. Plus, modern international law does have enforcement mechanisms.
Like what?
Like economic sanctions, UN Security Council resolutions, and the International Court of Justice.
And within this debate, there's a vital concept from another positivist jurist named Ancelotti, which kind of explains why states obey these rules even without a world police.
Yes, Ancelotti argued that the entire binding force of international law rests on one supreme fundamental norm. In Latin, it's pacta sunt servanda.
Pacta sunt servanda. Okay, what does that translate to?
It simply means agreements must be respected. It's the absolute bedrock of the international system.
Okay.
It implies that states observe international law not because of a higher moral calling, but because they have consented to do so, and the entire system collapses if states cannot trust each other to keep their promises.
So if positivists rely entirely on consent and treaties, how does the natural law theory fit in? The idea that there's an ideal law dictated by human reason or nature.
Well, natural law provides the moral architecture of the system. Positivists say law is only what states explicitly consent to, but naturalists argue there are higher, immutable rules dictated by human reason that bind states whether they explicitly consent to them or not.
Interesting.
If we connect this to the bigger picture, natural law is the philosophical foundation for universal human rights. Even if a brutal dictator hasn't signed a specific human rights treaty, natural law theorists argue they are still legally bound by fundamental human decencies simply by virtue of being part of the human race.
Let's make this highly practical for you listening. Think about the concept of diplomatic immunity. An ambassador lives in your capital city, they get pulled over for speeding, or worse, they commit a serious crime. Your local police do not arrest them. Why? Not because a global police force is standing guard over the ambassador, but because of mutual self-interest and centuries of customary adherence. We don't arrest their ambassador because we don't want them to arrest ours. That is the system working as actual law without a central sovereign commander.
Precisely. It is built on mutual consent, reciprocal interest, and a shared understanding that stability is just better than chaos.
So if it is real law, where's the rule book? Like if a judge in an international court needs to make a ruling, where do they physically go to read the law? This brings us to Section 2, the building blocks, the sources of international law.
For anyone studying this for the exam, you absolutely must know Article 38, Paragraph 1 of the Statute of the International Court of Justice, the ICJ.
Article 38, Paragraph 1.
It is universally recognized as the definitive, authoritative list of where international law comes from. It lists specific sources, and they operate in a clear hierarchy.
Let's hit the first and most powerful one, treaties, which are often called international conventions.
Right. Treaties are direct, explicit agreements between states. Because there is no global legislature passing statutes, treaties are the closest thing we have to international legislation.
And there are two main categories here, right?
Yes. First, you have lawmaking treaties. These are grand multilateral agreements entered into by a huge number of states that create general rules of universal application.
Like the UN Charter.
Exactly. The UN Charter, the Geneva Conventions on the Laws of War, or the UN Convention on the Law of the Sea, they effectively legislate for the globe. Second, there are treaty contracts, which are usually bilateral agreements.
Just between two states.
Right, creating specific obligations only for them, like a trade agreement or a border treaty between the U.S. and Canada.
But what if there isn't a treaty covering a specific dispute? The court then looks to the second major source, which is custom. And custom is arguably the oldest source of international law.
Custom is incredibly crucial, but it is deeply misunderstood. It's not just a habit. For a practice to become legally binding, customary international law, it requires two distinct elements.
What's the first one?
First, there must be a spontaneous, consistent, and general practice by states over a period of time. They have to actually be doing it. Second, and this is the magic, invisible ingredient, is opinio juris.
Let's break that Latin down. What exactly is opinio juris?
It means states must follow the practice out of a genuine sense of legal obligation, not just courtesy, convenience, or political habit.
So they have to feel like they're required to do it.
They do it because they believe international law requires them to do it. For example, states used to roll out the red carpet for visiting heads of state out of politeness. That's a habit. But states grant diplomatic immunity because they believe they are legally required to. That is custom.
The third source listed in Article 38, Paragraph 1 is General Principles of Law Recognized by Civilized Nations. Now, this sounds like a massive catch-all. How does a judge actually use this?
It operates as an essential gap filler. The international legal system isn't perfect, Sometimes there is no specific treaty and no clear customary practice has developed yet.
Because they're stuck.
Well, in a domestic court, a judge can't just throw up their hands and say, there's no law, I can't decide. International judges can't either. So they look at the domestic municipal legal systems of major nations around the world.
Ah, I see.
If almost all major legal systems share a fundamental underlying legal principle, like the concept of good faith in contracts, or the rule that a person cannot be a judge in their own case, or the concept of statutes of limitations.
The international court can just borrow that domestic principle to decide the international dispute.
Exactly.
Then we have what are called the subsidiary sources. Now, these don't actively create new law on their own, but they are tools to help figure out what the existing law actually is.
Right. The two subsidiary sources are judicial decisions and the writings of highly qualified publicists.
What does that mean in practice?
Judicial decisions mean rulings from international courts, like the ICJ, and sometimes major rulings from domestic Supreme Courts. While the ICJ doesn't have strict binding precedent, meaning one ruling doesn't strictly bind them in the next case, their previous decisions carry massive weight.
And the publicists.
Publicist refers to the most eminent legal scholars and jurists. If the top international law professors in the world all agree on how a rule should be interpreted, a court will heavily consider their writings. Finally, courts can sometimes use equity, which refers to overarching principles of fairness, though honestly, this is rare and highly subjective.
I want to dive deep into an incredible historical example of these subsidiary sources in action. Let's talk about the Alabama Claims Arbitration of 1872. How did an arbitration tribunal dealing with the aftermath of the American Civil War help literally build the foundation of international law?
The Alabama Claims is a brilliant narrative of how international law is forged in crisis. So, during the American Civil War, the British government officially declared neutrality. However, private British shipyards in Liverpool built and outfitted several warships for the Confederacy.
Oh, wow.
Yeah. The most devastating of these was the CSS Alabama. It roamed the globe, capturing and burning over 60 Union merchant ships. It caused massive economic devastation to the North.
And the U.S. was absolutely furious, right? When the war ended, they essentially blamed Britain for prolonging the war by supplying these commerce raiders.
You did.
They were demanding massive reparations, and tensions were so high that there was genuine talk of the U.S. invading Canada, which was British territory at the time, in retaliation. They were on the brink of another war.
Exactly. But instead of firing cannons, they did something revolutionary. They went to Geneva and hired lawyers.
I love that.
They signed the Treaty of Washington in 1871, agreeing to submit the dispute to an international arbitration tribunal. The tribunal consisted of representatives from the U.S., Britain, Italy, Switzerland, and Brazil.
That is wild. They essentially outsourced a potential war to a panel of international judges.
And the tribunal ruled against the British. They found that Britain had violated its customary duties as a neutral nation by failing to use due diligence to prevent the warships from being built and escaping its ports.
What was the penalty?
Britain was ordered to pay the United States $15.5 million in gold. But the money wasn't the most important part. The Alabama Claims set a monumental precedent for using peaceful judicial arbitration to settle massive geopolitical disputes. It proved that non-court tribunals could fundamentally shape customary law, establishing the rules of neutrality that we still study today.
Let's look at a scenario where these sources conflict.
Yeah.
What if there is a deeply established customary law, but two states signed a treaty that completely contradicts it? Which one wins?
Generally, a specific treaty will override customary law between the specific parties involved because the treaty represents their explicit recent consent. A landmark illustration of this is the SS Wimbledon case of 1923, decided by the Permanent Court of International Justice, which was the predecessor to the ICJ.
Break the Wimbledon case down for us. What were the actual stakes?
Okay, after World War I, the Treaty of Versailles forced Germany to keep the Kiel Canal, which is a crucial waterway cutting through German territory, open to the vessels of all nations at peace with Germany. Fast forward a few years. A war breaks out between Poland and Russia. A British ship, the SS Wimbledon, chartered by a French company, was carrying munitions to the Polish naval base. And Germany stopped the ship from entering the Kiel Canal.
Let me guess. Germany argued that under customary international law, as a neutral state in the Poland-Russia war, they had a duty not to allow foreign munitions to pass through their territory. They were relying on the very custom established by things like the Alabama claims.
Exactly. Germany argued custom demanded they block the ship to maintain neutrality, but the court ruled against Germany. They stated unequivocally that the specific written provisions of the Treaty of Versailles, which mandated the canal remain open, took priority over the general unwritten rules of customary international law regarding neutrality. Conventional rules, meaning treaties, trump custom between the signing parties.
Okay, so that covers Section 2. Let's move to Section 3, worlds colliding. How does this global rule book talk to local courts? Like, if I'm a judge sitting in a local domestic court in Ohio or London or Tokyo, do I care what a UN treaty says? Do I care about customary international law?
This brings us to the fascinating theoretical battle between monism and dualism. These are the two major frameworks explaining the relationship between international law and municipal law. And just a quick note, municipal is the legal term for domestic or national law.
Let's look at the monistic theory first. What is it?
Monists view international law and municipal law as one single, unified, seamless legal system. There are just two branches of the same tree. Crucially, in a strict monist system, international law sits at the top of the hierarchy.
Okay.
If a state signs and ratifies an international treaty, that treaty automatically, instantly becomes part of the domestic law. The domestic government doesn't need to pass a new, separate local bill to make it active.
I always think of this using a technology analogy. Monism is like an app that is built to run natively on your computer's operating system. The moment you download the treaty, it installs, and your domestic courts can just double-click it and use it immediately.
That's a great way to put it.
Dualism, on the other hand, is completely different.
Let's push that emulator analogy further. It is perfect. In the dualistic theory, international law and domestic law are two entirely separate, isolated operating systems. They govern entirely different relationships. International law governs state to state. Domestic law governs state to citizen.
Right.
For a dualist country, international law is fundamentally inferior domestically.
So if an international treaty is an iOS app, a strict dualist country is an Android phone. It literally cannot read the code.
Precisely. The international rule has to be translated. The state legislature must sit down and formally pass a brand new domestic law that essentially copy-pastes the treaty provisions into domestic code.
And what's the term for that?
This is called the specific adoption or transformation theory. Until the legislature passes that domestic act, the treaty means absolutely nothing to a local judge. The monist approach, conversely, relies on the delegation theory, arguing that the domestic constitution already inherently delegates the power to apply treaties directly to the courts.
So how does this actually look in practice? Like, which system do countries actually use?
State practice varies wildly. The United Kingdom is a classic, strict, dualist state regarding treaties. The UK executive branch can sign a treaty, but it has zero legal effect in a British court until Parliament specifically passes an act incorporating it.
What about the US?
The United States is a fascinating, messy hybrid. Customary international law is generally considered the law of the land, and under the U.S. Constitution, treaties are explicitly called the supreme law of the land, which sounds incredibly monist.
But there is a massive catch.
Yes. The U.S. requires treaties to be ratified by a 2/3 supermajority vote in the Senate, which is a notoriously high domestic hurdle. So it blends elements of dualism by requiring immense domestic legislative approval before the native app can run.
So what happens when there's a direct collision? What if a domestic law explicitly violates an international treaty? Let's say a country signs a treaty banning a certain pesticide, but the local Congress passes a law legalizing it.
Here is where the legal friction gets real. If a state's domestic law conflicts with international law, monists say the state is simply at fault and the international rule must legally prevail in court.
And the dualists?
Dualists say the domestic court is bound to follow the domestic law, even if it forces the state to breach an international treaty. However, here is the absolute golden rule of international law. On the international stage, a state can never use its own domestic law as an excuse or in defense for failing to honor an international obligation.
Wow, so you can't just say, my Congress made me do it.
Exactly. If your domestic Congress forces you to break a treaty, you will still be held liable internationally.
All right, so we've established how the law is made and how it interacts with domestic courts. Moving into Section 4, we need to ask, who actually gets to play the game? Who are the actual characters operating within this system? This brings us to the subjects of international law and the complex concept of statehood.
In legal terms, a subject of international law is an entity that possesses international legal personality. That means they have the capacity to possess rights and duties under international law, and crucially, the procedural ability to enforce those rights.
Like the ability to sue in an international court.
Exactly. There are three main theories on who qualifies for this VIP status.
The first is the realist theory.
Yes, this ties directly back to Oppenheim and the traditional orthodox positivist view we discussed at the beginning. The realist theory states that sovereign states, and only states, are the subjects of international law.
So individuals don't count.
Right. Individuals, corporations, and organizations are merely objects of the law. They're like property or territory, things the law acts upon, but not actors themselves.
Wait, if the realist theory says only states matter, the exact opposite of that is the fictional theory.
Yeah.
And I have to say, this one sounds entirely wild. It argues that only individuals are subjects of international law, and that states are essentially just legal fictions, just abstract, imaginary collections of individuals.
It is deeply provocative. Jurists like Hans Kelsen argued that all laws, domestic or international, ultimately apply to the behavior of individual human beings. The state doesn't have a soul. It doesn't have a mind.
Sure.
It's the human politicians who make decisions, human soldiers who fight, and human citizens who suffer the consequences of sanctions or war. Therefore, the state is just a legal fiction obscuring the fact that individuals are the true subjects.
I understand the philosophy, but practically, that sounds completely unworkable for a system literally called international law. I mean, how can individuals be the only subjects if an individual can't even sue another country in the ICJ? But there is a famous case in the sources that highlights the bizarre tension here, right? The Mavromatis Palestine concessions case from 1924. Can you break down how this case shows the state acting essentially as a legal shield for an individual?
The Mavromatis case perfectly illustrates the friction between these theories. Mavromatis was a Greek national, a businessman. Before World War I, the Ottoman Empire granted him lucrative concessions, essentially contracts, to build public works in Palestine, like tramways and water supplies.
Okay.
After the war, Britain took over the mandate for Palestine, and they refused to honor Mavromatis' contracts. They essentially gave the work to someone else.
So Mavromatis is furious. He's lost a fortune. But he's just one guy. Under the realist theory, he doesn't exist internationally. He can't sue the mighty British Empire.
Exactly. He had no legal standing. So what happened? The Greek government stepped in, Greece officially took up his claim, and sued Great Britain in the Permanent Court of International Justice on his behalf.
But Britain argued that the court shouldn't even hear the case, right? Because it was fundamentally just a private dispute between a guy and a government contract, not a true international dispute between two states.
That was the British defense. But the PCIJ delivered a landmark ruling. They stated that it is an elementary principle of international law that a state is entitled to protect its subjects when they are injured by acts contrary to international law committed by another state, from whom they have been unable to obtain satisfaction through the ordinary channels.
So the moment Greece picked up the file, it magically transformed from a private lawsuit into an international incident.
Precisely. By taking up the case of its citizen, the Greek state was asserting its own right, the right to ensure, in the person of its subjects, respect for the rules of international law. The individual suffers the actual injury, but only the state has the legal personality to demand justice.
That's a great bridge between the theories.
It is. It shows that individuals matter, as the fictional theorists claim, but they absolutely need the machinery of the state, as the realists claim, to protect them.
Which brings us to the third, most widely accepted modern view, the functional theory.
This is the pragmatic, realistic approach. It acknowledges that sovereign states are the primary dominant subjects of international law, but it recognizes that international organizations like the UN have attained legal personality.
Right.
And crucially, it recognizes that in very specific, limited contexts, individuals are subjects with distinct rights, like the right to petition international human rights bodies, and direct duties, like individual criminal responsibility for war crimes under the International Criminal Court.
Okay, since states are obviously the main characters of this drama, how do we legally define a state? If I buy an abandoned oil rig in the ocean, move 100 people there, and we all vote for mayor, why aren't we a country? What is the legal checklist?
To find the checklist, we look at the 1933 Montevideo Convention on the Rights and Duties of States. It codified 4 essential elements that an entity must possess to be considered a state under international law.
Number 1.
1, a permanent population. You need people. 2, a defined territory. You need physical land, though the borders don't have to be perfectly settled. 3, a government capable of maintaining order and controlling the territory.
And the 4th?
And 4, the absolute most critical ingredient, capacity to enter into relations with other states, which is legally synonymous with sovereignty.
Let's hone in on sovereignty because that is the missing ingredient for my oil rig commune. You can have people, land, and a government like the state of California or the province of Quebec or Scotland, but without sovereignty, you aren't an independent nation on the global stage.
Sovereignty is the ultimate superpower in international law. It has 2 dimensions. Internal sovereignty means the state has absolute, supreme, overarching authority over everything and everyone within its borders.
And external.
External sovereignty means absolute equality with other nations on the global stage. It means you are completely independent of foreign control, and crucially, you cannot be forced to accept international rules or court jurisdictions without your explicit consent.
Right.
California has internal government, but it lacks external sovereignty. It cannot sign a treaty with France or declare war on Canada. Only the federal U.S. government has that sovereign capacity.
But not all states are created equal in their structure. The law recognizes different kinds of states. We have federal states, where sovereignty is essentially divided internally between a central government and local units, like the U.S., Canada, or India. We have confederations, which are much looser unions of independent states that join together for a specific purpose, like defense or trade, while retaining their individual sovereignty.
And then we get into historical and modern anomalies. States with limited or shared sovereignty. You have protected states or protectorates. These are entities that possess internal autonomy, but have formally handed over control of their foreign policy and external defense to a stronger nation, often through a treaty. They are essentially half-sovereign.
And neutralized states.
Neutralized states, like Switzerland.
Switzerland is the classic example.
Yes. A neutralized state's political independence and territorial integrity are permanently guaranteed by an international treaty signed by major powers. In exchange, the neutralized state agrees never to wage offensive war and never to enter into alliances, like NATO, that might drag them into a conflict.
And there is one incredibly strange oddity that I want to highlight from the syllabus, the condominium state.
It is a fascinating legal concept. A condominium occurs when a specific piece of territory is jointly governed by 2 or more sovereign powers who agree to share the duties of administration without actually dividing the land into separate national zones. They exercise joint sovereignty.
It sounds like a geopolitical nightmare to administer. Has it ever actually worked?
It has existed historically. For over 50 years, Sudan was administered as an Anglo-Egyptian condominium ruled jointly by Britain and Egypt. Another example was the New Hebrides, a group of islands in the Pacific, which was managed jointly by Britain and France for over 70 years until they gained independence as Vanuatu.
Wow.
It's rare today, but it proves how incredibly flexible the concepts of statehood and territorial control can be in international law to solve complex political disputes without resorting to war.
That concept of territory transitions us perfectly to Section 5, the global map. We know territory is a mandatory physical element of a state. You have to have land. But how do states legally acquire it? How do they lose it? And where exactly does their power end when the beach hits the ocean? Let's talk about acquiring territory first.
Historically, international law recognized several specific modes of acquiring territory. Some are obsolete, but they are crucial for understanding historical land claims. The first is occupation. In legal terms, this doesn't mean military occupation.
What does it mean then?
It means a state intentionally appropriating land that truly belongs to no one. The Latin term is terra nullius. It implies claiming unowned land and establishing real, effective administration over it.
Then there is prescription. I want you to explain how this actually works because it sounds like legally stealing land. It's defined as acquiring territory by exercising peaceful, continuous control over it for a long period of time without the original owner objecting. How does a country quietly take over another country's land?
It is essentially the international law equivalent of squatters' rights or adverse possession. Imagine a remote, poorly mapped border region between State A and State B. State B officially owns it on a 200-year-old map. But State A slowly starts building roads there.
Okay.
They set up a post office, they start collecting taxes from the few locals, they apply their criminal law. State A does this openly, peacefully, and continuously for decades. State B, perhaps distracted or weak, never sends a diplomatic protest. They never try to evict State A's officials.
And eventually.
Under the doctrine of prescription, international law values stability over ancient maps. If State A exercises sovereign authority long enough without State B objecting, the legal title eventually shifts to State A.
Wow. If you don't use it and defend it, you lose it. What are the other modes?
Accretion is when territory is added naturally, like a river delta slowly expanding into the sea, or a volcanic island forming within territorial waters. Cession is the formal, legal transfer of land from one sovereign state to another, almost always by treaty. This could be a sale, like the U.S. buying the Louisiana Territory from France, or a gift, or an exchange.
And then there's annexation, which is acquiring territory by military conquest.
And we must emphasize that this has radically changed. Historically, conquest was a perfectly legal way to acquire territory. But under modern international law, specifically Article 2, Paragraph 4 of the UN Charter, the threat or use of force against the territorial integrity of another state is strictly prohibited.
So it's illegal now.
Annexation by military force is now entirely illegal. Finally, there is adjudication, which is when an international tribunal or court officially assigns territory to settle a boundary dispute between two nations.
And naturally, how you legally gain territory is often how someone else loses it. Loss of territory happens through cession, through the operation of nature, like an island eroding away, through violent revolt leading to a successful secession, or when an imperial state formally grants independence to a former colony.
Now let's turn away from the land and look out at the ocean. The law of the sea is an incredibly complex, vital framework. It divides the water into distinct jurisdictional zones, all measured outward from the coast's low-water baseline.
Walk us through the zones, starting from the beach.
First, you have internal waters. These are the lakes, rivers, ports, and bays that lie inside the baseline. Legally, internal waters are treated exactly like land territory. The state has absolute full sovereignty. They can ban foreign ships entirely.
Next out is the territorial sea, which extends up to 12 nautical miles from the coastal baseline. The coastal state has sovereignty here too, but with one massive, globally recognized exception: the right of innocent passage.
Yes. Foreign ships, whether they are cargo ships or military vessels, have the customary right to travel continuously and expeditiously through another state's territorial sea, provided their passage is innocent.
Innocent meaning?
Innocent means it is not prejudicial to the peace, good order, or security of the coastal state. So a foreign submarine can't travel submerged. It must surface and show its flag. A foreign warship cannot conduct weapons practice while passing through.
Moving further out, we hit the contiguous zone, which stretches up to 24 nautical miles from the baseline.
Here, the state's tower de loops. It does not have full sovereignty in the contiguous zone. Instead, it has specific, limited policing rights. The state can exercise the control necessary to prevent and punish infringements of its customs, fiscal, immigration, or sanitary laws.
Like a buffer zone.
It's essentially a buffer zone to catch smugglers or intercept illegal immigration before they reach the territorial sea.
Then we arrive at a massive economic concept: the continental shelf. This deals with the seabed itself.
Yeah.
To understand this, we have to talk about the Truman Proclamation of 1945. Why did a speech by a U.S. president revolutionize global maritime law?
Because it is one of the most stunning examples of a unilateral state action creating instant customary international law. Post-World War II, the U.S. realized it needed vast new oil reserves, and technology was advancing to allow offshore drilling.
Okay.
In 1945, President Harry Truman unilaterally issued a proclamation declaring that the United States had exclusive sovereign rights over the natural resources of the seabed and subsoil of its continental shelf, extending far out into the ocean, way beyond the traditional territorial sea.
But wait, didn't that violate the ancient freedom of the seas? If the U.S. claimed the ocean floor 100 miles out, weren't they claiming the ocean itself?
That was the brilliance of the proclamation. The crucial legal distinction Truman made was that the U.S. was only claiming jurisdiction over the seabed resources, the oil, the gas, the minerals. He explicitly maintained that the waters above the shelf remained international waters, high seas.
Ah, surgical strike.
It was a surgical legal strike. It protected vital economic interests without destroying the ancient freedom of navigation. Because it was so economically beneficial, almost every other coastal state immediately copied the U.S. Within a few years, what started as a unilateral American claim crystallized into binding customary international law, giving coastal states exclusive rights to mine their continental shelves.
And finally, beyond all of this, we have the high seas.
The open ocean. It is governed by the principle of res communis, meaning it belongs to everyone and no one. All states, coastal or landlocked, have the absolute freedom of navigation, overflight, fishing, and laying submarine cables. No sovereign state can legally claim any part of the high seas.
Okay, I have a scenario for you. Let's talk about the doctrine of hot pursuit. It sounds like an action movie, but it tests the exact boundaries of these maritime zones. Let's say a foreign smuggling ship breaks a customs law while inside my territorial waters. My Coast Guard spots them, turns on the sirens, and the smugglers make a run for it. They cross the 12-mile line, cross the 24-mile line, and burst out into the high seas. Doesn't the high seas mean they are legally safe from my jurisdiction?
They are absolutely not safe, provided your Coast Guard initiates a legal hot pursuit. International law recognizes that a coastal state's sovereignty would be meaningless if a criminal could just outrun them to the 25-mile mark. The doctrine allows a coastal state's warships or military aircraft to chase a fleeing foreign vessel out into the high seas and forcefully arrest them.
What are the legal requirements for the chase?
There are strict rules. The pursuit must begin while the foreign ship is physically within the coastal state's internal waters, territorial sea, or contiguous zone. The coastal state must give a clear visual or auditory signal to stop. Most importantly, the pursuit must be hot and continuous. It cannot be interrupted. If the Coast Guard loses them on radar and finds them 2 days later, the right of hot pursuit is broken.
And when does the chase actually have to stop?
The right of hot pursuit ends the moment the fleeing ship enters the territorial sea of its own home state, or the territorial sea of a third independent state. At that exact moment, the pursuing ship must break off, because continuing the chase would violate the territorial sovereignty of that other nation. It is a vital exception that balances a state's right to protect its laws against the freedom of the open ocean.
Brilliant. So let's transition from the physical map to the political map in Section 6. You have a defined territory, you have a government, you have a population. You meet all the criteria of the Montevideo Convention. But you aren't truly part of the global club until the other members officially acknowledge you. This brings us to the highly political theater of the recognition of states.
Recognition is the formal, official acknowledgement by existing states that a newly emerged entity actually possesses the legal characteristics of statehood. It is arguably the most highly political act in international law, but it comes with massive, concrete legal consequences.
Because without it, you're paralyzed.
Because without recognition, your statehood is essentially paralyzed. There are two deeply opposing theories on how the mechanics of recognition actually work.
The constitutive theory versus the declaratory theory. Break these down.
The constitutive theory, heavily supported by traditionalists like Oppenheim, argues that recognition is the magic wand. It says that a state literally, legally does not exist as an international person until it is formally recognized by other existing states.
Oh.
In this view, it is the act of recognition by others that actually creates or constitutes the legal personality of the new state. If no one recognizes you, you are legally invisible.
The declaratory theory, which is favored by the Montevideo Convention, argues the exact opposite.
Right. The declaratory theory argues that statehood is purely a question of objective fact. It says a state legally exists the absolute millisecond it fulfills the four factual elements: population, territory, government, and sovereignty. In this view, recognition by other states doesn't create anything. It is merely a formal declaration acknowledging a factual reality that already independently exists.
In actual geopolitical practice, it's a messy blend of both, right? I mean, you might exist factually, you might have an army and a flag, but if no major powers recognize you, you can't sign multilateral treaties, you can't access international banking systems, and you certainly can't get a seat at the United Nations. Now, when a state does decide to recognize another, it can do so in two different modes, de facto or de jure. What is the difference?
This is a critical distinction. De facto recognition is provisional, temporary, and based purely on the factual reality that a new government seems to have effective control over a territory. It's like a political test run. A state might grant de facto recognition if they see a new entity has power, but they seriously doubt its long-term stability or they disapprove of how it came to power.
And de jure.
De jure recognition, however, is the gold standard. It is final, complete, legal, and generally irrevocable. It is granted when the existing state is fully satisfied that the new state fulfills all the conditions of statehood permanently and legitimately.
Let's use an analogy here. Imagine applying for a highly restricted professional license. De facto recognition is like being handed a provisional learner's permit. You are allowed to drive on the road, you exist in the system, but the permit can be easily revoked, you have restrictions on what you can do, and the government is watching you closely to see if you crash. De jure recognition is when you pass the final test and they hand you the permanent, full driver's license. It is legally binding, complete, and grants you every right on the road.
That is a much better analogy. And the legal effects reflect that difference perfectly. A state that only has de facto recognition is severely limited. They do not get full, absolute diplomatic immunities for their representatives. And crucially, a de facto entity cannot undergo state succession.
What does that mean?
Meaning they cannot legally inherit the state property or the fiscal assets of the previous regime located in foreign banks. Foreign courts won't release the money to a merely de facto government. De jure recognition unlocks all of that. Absolute rights, full diplomatic immunities, and the legal ability to claim state property globally.
I want to clarify something here for the listener. Are we talking about recognizing a new country or recognizing a new government inside an old country?
That is a vital distinction. Recognizing a new state, like when South Sudan broke away from Sudan, is acknowledging a brand new international person. Recognizing a new government is entirely different. If a country changes its government through a normal democratic constitutional election, no formal recognition is required by the rest of the world. The state remains the same.
But if there's a coup?
Right. If a government is overthrown in a violent military coup or a bloody revolution, the existing states of the world must pause and decide whether they will recognize this new regime as the legitimate voice of that state.
What checklist do they use to decide?
When deciding whether to recognize a revolutionary government, foreign states primarily look at two things. First, effective control. Does the new regime actually control the territory and the administrative machinery of a state without massive ongoing resistance? Second, and more politically, are they willing and able to fulfill the existing international obligations and treaties of the state? If the new revolutionary leader announces they are tearing up every treaty and seizing all foreign assets, other states will likely withhold recognition.
Okay, so we've established how a state gets recognized and welcomed into the international system. But once you're in the club, how far does your legal power actually reach? Can a state punish crimes that were committed completely outside its physical borders? This brings us to Section 7, the complex web of state jurisdiction.
Jurisdiction is the beating heart of sovereign power. It is a state's legal capacity to prescribe rules, some make laws, to enforce them, police power, and to adjudicate disputes, try cases in court. The fundamental baseline rule of international law is territorial sovereignty. A state absolutely cannot physically enforce its laws or make arrests on foreign territory without the explicit consent of that foreign state.
But a state can claim the legal right to try someone in their own courts based on certain connecting principles. The most obvious is the territorial principle.
Yes. A state has primary, almost absolute jurisdiction over any crime or event that happens within its own physical borders, period. But the law splits this into two subcategories to handle complex crimes. Subjective territory jurisdiction is when a crime is planned or initiated inside your state, but the final act happens elsewhere. For example, a bomb is built in State A but mailed to State B where it explodes. State A has subjective jurisdiction.
And the reverse of that is objective territorial jurisdiction.
Correct. This is when a crime starts entirely outside your borders, but the effect is felt heavily inside your state. To go back to your intro hook, an assassin stands in State A and shoots a victim across the border in State B. State B has objective territorial jurisdiction to demand the assassin stand trial because the physical effect of the crime, the murder, happened on their soil.
Then there is the nationality principle, which basically says your home country's laws follow you around the globe like a shadow.
Exactly. Active nationality means a sovereign state has the right to prosecute its own citizens for crimes they commit anywhere in the world. If a French citizen commits a murder in Brazil and flees back to Paris, France has the jurisdiction to try them under French law, even though the crime happened 5,000 miles away.
What about passive?
Passive nationality is much more controversial. This is when a state claims jurisdiction over a foreign citizen who committed a crime abroad simply because the victim was a national of that state.
Okay, what about the protective principle? Let's say I am an alien, a non-citizen, living permanently in a foreign country. I've never set foot in your nation. But from my basement abroad, I start counterfeiting millions of your currency, or I start hacking into your military defense grid. Can you claim jurisdiction over me?
Yes, under the protective principle, you can. This principle allows a state to claim jurisdiction over a foreigner acting completely outside its territory if their actions are deemed a severe, direct threat to the state's vital security, its territorial integrity, or its core governmental functions.
So things like treason.
Treason, espionage, massive counterfeiting, or plotting a violent coup from abroad all trigger this. It is a defensive mechanism designed to allow states to protect themselves from existential threats hatched beyond their borders.
Let's ground this in one of the most famous cases in international law history, the Lotus case of 1927. This case involves a deadly collision at sea, and it essentially defined how jurisdiction works when territories crash into each other. Paint the scene for us.
It's August 1926, just before midnight on the high seas of the Aegean. The Lotus, a massive French mail steamer, violently collides with a smaller Turkish coal ship called the Bozkurt. The Turkish ship is torn in half and sinks rapidly. 8 Turkish sailors and passengers drown in the dark. The French ship rescues the survivors and sails on to Istanbul, Turkey, to dock.
And the moment the French ship docks, the Turkish authorities board it. They arrest the French officer of the watch, Lieutenant Demons, and they charge him with manslaughter under Turkish law. France is absolutely outraged.
France protests vehemently. Their legal argument was straightforward. The collision happened on the open high seas, not in Turkish waters. Under international law, a ship on the high seas is treated legally as a floating piece of the territory of the nation whose flag it flies.
Right.
Therefore, the French officer was standing on French territory when he made the navigational error. France argued that Turkey had absolutely zero jurisdiction to arrest and try a French citizen for an act committed on a French ship on the high seas.
So the dispute goes to the Permanent Court of International Justice. What does Turkey argue?
Turkey didn't deny the French ship was French territory, but they argued that the Bozkurt was equally a piece of Turkish territory. They argued that the French officer's negligence was an act that started on the French ship, but the deadly effect, the crushing of the hull and the deaths of the sailors, physically occurred on the Turkish ship. Therefore, Turkey claimed they had objective territorial jurisdiction.
And the court agreed with Turkey.
They did, in a razor-thin, highly controversial decision. The PCIJ ruled that Turkey had not violated international law by prosecuting the French officer. Because the effects of the crime were felt on a vessel flying the Turkish flag, Turkey had concurrent jurisdiction alongside France. But the most famous, lasting legacy of the Lotus case wasn't just about ships.
What was it?
The court delivered a sweeping philosophical statement. They said that international law permits all state actions that it does not expressly forbid. They famously declared, "Restrictions upon the independence of states cannot therefore be presumed." It set a precedent that sovereign states have incredibly wide latitude to act unless a specific international rule tells them they cannot.
That is massive. Now, we've talked about jurisdiction based on territory, nationality, and protection. But what about crimes that are just universally, undeniably abhorrent?
That brings us to the universality principle. For certain heinous crimes that are considered to be against the international community as a whole, historical crimes like piracy and slavery, and modern crimes like genocide, war crimes, and increasingly international terrorism and aircraft hijacking, any sovereign state in the world has jurisdiction to arrest and try the offender. It does not matter where the crime happened. It does not matter what nationality the perpetrator is. It does not matter what nationality the victims are. Because the criminal is deemed an enemy of all mankind, hostis humani generis, every nation has a vested interest in bringing them to justice.
I want to look at how far powerful states will stretch these principles. The syllabus materials reference the United States v. Noriega case from 1990. General Manuel Noriega was the de facto military dictator of Panama. The U.S. didn't just indict him, they literally invaded his country, captured him, brought him back to Miami in chains, and put him on trial for drug trafficking and racketeering. How on earth did the U.S. legally justify trying the leader of a foreign country?
It is a stunning assertion of extraterritorial jurisdiction. The U.S. courts relied heavily on a combination of the objective territorial principle and the protective principle. They argued that even though Noriega's drug smuggling operations were organized in Panama, the devastating effects of those drugs were intentionally aimed at and felt violently within the United States.
So the protective aspect came in too.
Yeah, they argued his actions were a direct threat to the security and health of the U.S. population. It demonstrates how aggressively powerful states will expand jurisdictional concepts to grab individuals across borders.
But Noriega didn't just sit there. He argued he was immune from prosecution entirely, which brings us to a massive exception to all these jurisdictional rules: sovereign immunity.
Right. Sovereign immunity is based on the ancient Latin maxim par in parem non habet jurisdictionem, meaning equals have no jurisdiction over each other. A domestic court in one state generally cannot force a foreign sovereign state or its head of state to stand trial. Noriega argued that as a leader of Panama, he possessed head of state immunity, and a Miami court had no authority to judge his official acts.
Why did that defense fail?
The U.S. court denied his immunity for a fascinating political reason. They noted that Noriega had never been constitutionally elected, and crucially, the U.S. executive branch had never officially recognized him as the legitimate de jure head of the Panamanian state. Because he lacked recognition, he lacked the shield of immunity.
It all connects back to recognition. But sovereign immunity itself is evolving, isn't it? It used to be absolute, but now it's restricted.
Yes, the modern world uses the restrictive immunity doctrine. As governments started acting more like corporations, buying businesses, running airlines, signing massive commercial contracts, absolute immunity became unfair to private businesses. Now we draw a line.
Where's the line?
A foreign state gets absolute immunity for its sovereign public governmental acts, known in Latin as jure imperi. But a foreign state does not get immunity if it engages in private, commercial, business acts, jure gestionis. If the French government signs a treaty, you can't sue them in a local court. But if the French government buys 1,000 computers from a local tech company for their embassy and refuses to pay the bill, they are acting as a commercial entity, and they can be sued for breach of contract just like any normal corporation.
And briefly, we also have diplomatic immunity, which is related but distinct. This protects individual diplomats and their embassies from local criminal and civil jurisdiction, ensuring they can conduct international relations without the fear of being harassed or arrested by the host country on trumped-up charges.
Exactly. It's the grease that keeps the wheels of international diplomacy turning.
All right, let's pivot to Section 8, the domino effect. We've established how far a state's power reaches while it is alive and functioning. But states aren't immortal. Borders shift. Empires collapse, countries split in two. What happens when a state's jurisdiction completely collapses or permanently merges with another? Who inherits the legal mess? This is the law of state succession.
State succession is arguably one of the most complex areas of international law. It occurs when one state permanently replaces another in the responsibility for the international relations of a specific territory. It generally takes two forms.
What's the first?
There is universal succession, where an entire state completely disappears, like when East and West Germany merged, or when a state is entirely subjugated and annexed. And then there is partial succession, where a state still exists, but a piece of its territory breaks off to form a brand new state, like when South Sudan seceded from Sudan, or the massive wave of decolonization in the 20th century.
When a new state takes over, what happens to all the treaties, the debts, and the property of the old state? Do they automatically inherit them? There are competing theories on this, right?
Historically, jurists like Grotius favored the universal succession theory, which argued that the new state automatically inherits all the rights, duties, and obligations of the predecessor state, much like an heir inheriting an estate in private law. Another view is the popular continuity theory, which suggests that while the political government might change, the social identity, the people, and the land remains the same, so the legal obligations linked to the territory should continue.
But newly independent states, especially former colonies, absolutely hated those theories. They championed the clean slate theory.
And understandably so. The clean slate theory, which is heavily favored in modern practice by decolonized nations, argues that a newly emerged successor state is completely free of the political obligations and treaties of its colonial predecessor. They argue they shouldn't be bound by oppressive treaties they never consented to. They start fresh.
Let's try to clarify this mess with an analogy. State succession is like buying a heavily used car. Under the clean slate theory, you, the new owner, absolutely do not take on the previous owner's personal parking tickets or their expensive gym membership. In international law, those are political treaties, military alliances, peace treaties, or extradition agreements. They are deeply personal to the old regime, and they absolutely die with the old state. They do not pass on.
The analogy holds up perfectly when we look at exceptions. You don't inherit the parking tickets, but you do have to honor the physical reality of the car. You have to respect the property lines of your driveway where you park it. In international law, these are called real or territorial treaties.
Like border.
Right. Treaties that define national borders or grant transit rights over a river or regulate a shared railway absolutely do pass to the successor state. The law enforces this to prevent instant border wars and maintain global territorial stability.
What about the car loan? What happens to the billions of dollars of national debt?
Fiscal debts usually transfer to the new state. If a state splits into three, the international debt is usually apportioned between them based on an equitable ratio, often based on how much of the territory, resources, or population each new state took.
And crucially, what happens to human rights treaties?
This is a major modern development. Human rights treaties are increasingly considered to pass on automatically to the successor state. The logic is that human rights belong to the people living in the territory, not the political regime. A change in government shouldn't strip millions of people of their fundamental legal protections.
Now, what if an existing state simply does something wrong? What if they break a treaty or their military illegally attacks someone? This triggers the law of state responsibility.
State responsibility is the international equivalent of civil liability. It arises when a state commits an internationally wrongful act. Establishing this requires two rigid elements. First, there must be an actual breach of a binding international obligation, whether it's a treaty, a custom, or a general principle.
And the second element?
Second, and this is where it gets incredibly tricky, that breach must be legally attributable to the state.
Meaning the state actually did it. But a state is an abstract entity. France doesn't have hands, it can't physically punch someone. A state acts entirely through human beings.
Exactly. The rules of attribution dictate which humans represent the state. Obviously, the actions of the official organs of the state, the military, the national police, the executive branch, the legislature, and even the judiciary are directly attributable to the state. If the national army crosses a border, the state is responsible. But the general baseline rule is that a state is not legally responsible for the acts of its private citizens.
So if a massive mob of angry private citizens decides to attack a foreign embassy and burn it down, the host state isn't automatically legally responsible for the damages.
Correct, unless there is an attribution link. The state isn't responsible for the mob's anger, but the state is responsible if it failed its own due diligence. If the state knew the mob was gathering and intentionally failed to send adequate police protection to the embassy, that failure is a breach of its own duty to protect diplomats.
Wow.
Furthermore, if private citizens are essentially deputized and exercising governmental authority, or if the state officially praises, adopts, and endorses the mob's actions after the fact, like Iran did during the 1979 hostage crisis, the private act legally transforms into an act of the state.
I want to look at who is actually allowed to complain when a rule is broken. For a century, international law was strictly bilateral. If State A harmed State B, only State B could sue. State C had to mind its own business. But the Barcelona traction case completely shattered that. How does a complex case about a bankrupt tower company relate to global state responsibility?
The Barcelona traction case of 1970 is an absolute titan of international jurisprudence. The facts are incredibly dense. Barcelona Traction was a power company incorporated in Canada, but it operated entirely in Spain, and the vast majority of its shareholders were Belgian citizens.
Okay, complicated.
After the Spanish Civil War, the Spanish government took a series of actions that essentially bankrupted the company and wiped out the Belgian investors. Belgium decided to sue Spain and the ICJ for ruining their citizens' investments.
So Belgium is stepping in to protect its people, just like Greece did in the Mavromatis case we discussed earlier.
Exactly. But Spain argued that Belgium had no legal standing. Spain said, the company is legally Canadian. If anyone was injured, it was Canada. Belgium has no right to interfere. The ICJ ultimately agreed with Spain, ruling that only the state of the company's incorporation, Canada, had the right of diplomatic protection, not the state of the shareholders.
Okay, so Belgium loses. But why is this case so famous if it's just about corporate nationality?
Because in the middle of their ruling, the ICJ delivered what jurists call dicta, a profound legal observation that changed the world. The court drew a sharp distinction between obligations a state owes to another specific state, like a bilateral trade agreement, and obligations a state owes to the international community as a whole. They named these universal duties obligations erga omnes.
Towards all.
Yes. The court explicitly stated that some rights are so vital, so fundamentally important to the existence of humanity, that every state has a legal interest in their protection. The court gave examples: the outlawing of acts of aggression, the prohibition of genocide, and protection from slavery and racial discrimination.
Okay.
If a state commits genocide against its own people inside its own borders, they are violating an erga omnes obligation. Because the duty is owed to everyone, any state in the world has the legal standing to complain and demand it stops, even if they aren't directly injured. It marked a colossal philosophical shift from strict, selfish bilateralism to the legal protection of global community interests.
That is a perfect segue into Section 9, the human element. We have spent an hour dissecting sovereign states, massive institutions, and shifting borders. But how does the everyday individual human being actually plug into this massive, terrifying system? The answer is nationality.
Nationality is the crucial physical link between the individual and international law. We must draw a very sharp distinction between nationality and citizenship because people use them interchangeably, but legally they are different.
How so?
Citizenship is your status under domestic municipal law. It determines your internal rights: the right to vote in local elections, the right to hold public office, the right to an internal passport. Nationality is your status under international law. It determines which sovereign state has the right to legally protect you on the hostile global stage.
So what does this actually mean for the individual? Let's connect it all the way back to the fictional theory we debated at the very beginning, the idea that states are just fictions protecting people.
The reality of nationality validates the deep concerns of the fictional theorists. Without a nationality, if you are legally stateless, perhaps because your country collapsed or you were stripped of it by a dictator, you are incredibly, profoundly vulnerable.
You're unprotected.
You essentially have zero protective shield in the international arena. If a foreign government illegally seizes your property, tortures you, or throws you in prison without a trial, no state has the legal right to step in, file a diplomatic protest, or sue them in an international court on your behalf. The system demands that an individual possess a nationality so that a state can trigger the machinery of international justice for them.
How does an individual actually acquire this vital protective shield?
It is entirely up to the domestic law of each state to determine who its nationals are, but international law recognizes several standard modes. You can acquire it by descent, meaning you inherit the nationality of your parents, known as jus sanguinis. You can acquire it by birth within the physical territory of the state, known as jus soli.
Naturalization.
Yeah, you can gain it through naturalization, which involves applying, living there for years, and taking a test. You can get it by resumption, getting it back after legally losing it, or you can acquire it by option, which happens during state succession. If a territory splits, the people living there are often given the option to choose which new state's nationality they want.
And what happens if an individual commits a heinous crime in their home state and uses their passport to flee across a border into a foreign country? This brings up the mechanics of extradition.
Extradition is the formal legal process where one state surrenders an accused or convicted criminal to another state at its request so the fugitive can stand trial or serve their sentence. It is the intersection of criminal law and international diplomacy.
Why do states agree to do this? If a foreign murderer runs into my country, international law doesn't automatically force me to hand him back, right?
Correct. There is absolutely no general binding customary duty in international law to extradite fugitives. If there is no specific extradition treaty between the two countries, the host state can legally refuse to hand them over.
But they do it anyway.
But states routinely sign bilateral extradition treaties because it serves a vital mutual purpose. It ensures that criminals cannot treat international borders like a magical get-out-of-jail-free card. It ensures that offenders are put on trial in the specific jurisdiction where the crime actually happened, which is logically where the physical evidence, the crime scene, and the witnesses actually are. It is a system built on reciprocal self-interest to prevent sovereign nations from becoming safe havens for global fugitives.
All right, we are in the home stretch, Section 10. We have explored the deep philosophy, the ocean borders, and the fate of criminals. Let's look at the actual architecture holding it all together. Treaties and international organizations. How do states formally, legally agree on complex things like extradition, nuclear disarmament, or global trade? They write treaties, and they build massive organizations to manage them.
We touched on treaties as a source of law earlier, but let's look closer at the mechanics. The absolute pulsing heart of treaty law is the principle of pacta sunt servanda, the rule that every treaty in force is binding upon the parties and must be performed by them in good faith.
Does a treaty have to look a certain way?
Interestingly, international law is incredibly flexible here. It does not require a specific, rigid format for a treaty to be valid. It can be a massive formal convention bound in leather, it can be a quick protocol, or it can simply be an official exchange of diplomatic letters. The only mandatory, non-negotiable element is the clear, objective intent of both states to create legally binding relations.
And to make sure the person sitting at the table signing the document actually represents the country, they need to produce what are called full powers.
Yes. Full powers is a formal document emanating from the competent authority of a state, usually the president or the foreign minister, designating a specific person to negotiate and sign a treaty on behalf of the state. It prevents rogue diplomats from legally binding their nations to insane agreements. Heads of state, heads of government, and ministers for foreign affairs are considered to inherently possess full powers without needing the document.
Now, when states sign massive multilateral treaties, they often build international organizations to run them. And the granddaddy of them all is the United Nations. The UN Charter is essentially the foundational constitution of the modern international community. But it has strict built-in limits to protect the sovereignty of its members. The study materials highlight a massive source of tension. Article 2, paragraph 7 of the Charter.
Article 2, paragraph 7 is the Domestic Jurisdiction Clause, and it is the ultimate shield for sovereign states. It explicitly states that absolutely nothing in the UN Charter authorizes the United Nations to intervene in matters which are essentially within the domestic jurisdiction of any state.
So they can't meddle.
The UN cannot dictate a country's internal tax code, how it runs its local elections, or its municipal zoning laws. Those are purely internal sovereign affairs.
But the definition of what is considered a domestic affair is rapidly shrinking, isn't it?
Yeah.
I mean, decades ago, how a brutal dictator treated his own citizens inside his own borders was considered a purely internal, domestic issue. The rest of the world had to look away. But now,
the wall between domestic and international has become incredibly porous. The massive expansion of international human rights law has fundamentally pierced the veil of state sovereignty. Today, massive human rights violations, genocide, or apartheid are no longer considered essentially within domestic jurisdiction.
they trigger obligations.
They are matters of profound international concern, triggering the erga omnes obligations we discussed earlier, and the UN Security Council can authorize sanctions or even military intervention to stop them, bypassing Article 2, paragraph 7 entirely.
Finally, we must discuss the judicial organ that tries to sort out all these disputes. The International Court of Justice, the ICJ, sitting in The Hague. It's the highest court in the world, but it operates with massive handicaps. First of all, only states can be parties in contentious cases before the court. A private corporation or an individual human rights victim cannot sue a state there.
And the most profound handicap is the ICJ's jurisdiction. In a domestic system, if someone sues you, you are forced to go to court. You get a subpoena. The ICJ does not have that power. Its jurisdiction is based entirely, 100%, on the consent of the sovereign states involved. It operates in 3 ways.
What's the first?
First is contentious jurisdiction, where 2 states have a dispute and they explicitly sign an agreement to bring that specific case to the court. Second is advisory jurisdiction, where the court isn't deciding a dispute, but rather organs of the UN, like the General Assembly, ask the court to provide a formal legal opinion on a complex question of international law.
And the third type is the most dramatic. Compulsory jurisdiction under the optional clause. This is where things get explosive.
The optional clause allows states to make a sweeping unilateral declaration in advance. They announce to the world, "We recognize the jurisdiction of the ICJ as compulsory without needing a special agreement for any future legal disputes, provided the other state has made the same pledge." It's an attempt to create a truly binding, mandatory global court system.
Let's analyze a case that pushed this to the absolute breaking point. Let's look at the landmark case of Nicaragua v. United States from 1984. Set the stage for us.
It is the middle of the Cold War. The leftist Sandinista government is in power in Nicaragua. The United States, fearing communist expansion in Central America, begins heavily funding, training, and arming a rebel group known as the Contras to overthrow the Nicaraguan government. The CIA also directly participates in covert operations, including laying underwater mines in Nicaragua's sovereign harbors, which damaged international shipping.
Nicaragua is a small country. They can't fight the U.S. military. So they do what the U.S. did back in the Alabama claims. They go to court. They sue the United States at the ICJ, claiming the U.S. was violating fundamental customary international law by using illegal force and intervening in Nicaragua's domestic affairs. But the U.S. immediately tries to shut the case down.
The United States arrived at The Hague and flatly argued that the ICJ had absolutely no jurisdiction to hear the case. The U.S. stated, "We do not consent to be sued by Nicaragua over an ongoing armed conflict." They argued it was a political issue for the UN Security Council, not a legal issue for the court.
But Nicaragua pulled a brilliant legal maneuver. They pointed out that decades earlier, the United States had signed an optional clause declaration. The U.S. had previously promised to accept compulsory jurisdiction.
Yes. The ICJ looked at the U.S.'s prior declaration and ruled against the American objection. The court stated that because the U.S. had voluntarily accepted compulsory jurisdiction in the past, they were legally bound to face the lawsuit now, even if they desperately wanted to back out. The case proceeded, the U.S. refused to participate in the merits phase out of protest, and the ICJ ultimately delivered a crushing ruling against the United States, finding that they had indeed violated customary international law regarding the illegal use of force and non-intervention. The court ordered the U.S. to pay reparations.
But the U.S. refused to pay and used its veto power on the UN Security Council to block enforcement. I'm going to speculate that the concept of compulsory jurisdiction is actually the tragic Achilles heel of the ICJ, because immediately after that devastating ruling, what did the U.S. do? They formally withdrew their consent to the optional clause. They walked away. It proved that even at the highest levels of international justice, sovereignty is still the ultimate trump card. If a global superpower decides it doesn't want to play by the rules, it can just take its ball, revoke its consent, and go home.
It perfectly highlights the central, agonizing tension we started with in the very first minute of this deep dive. The entire architecture of international law, despite its brilliant theories, its profound human rights treaties, and its elegant courts, still relies almost entirely on the ongoing consent, the political will, and the good faith of sovereign states.
Okay, let's pull all these massive threads together. We have traced the lifeblood of public international law from the philosophical debates of Austin and Maine through the intricate mechanisms of treaties and ancient custom. We've seen how states are legally born out of facts and recognition, how they acquire vast territories out into the depths of the ocean, and how far their jurisdictional power reaches to punish crimes.
We really covered a lot.
We've looked at the chaos of what happens when states die and pass on their debts, how individuals seek the vital protective shield of nationality, and how institutions like the UN and ICJ try desperately to hold it all together in a world without a supreme commander.
It is a massive, awe-inspiring, and constantly evolving legal ecosystem. It is flawed, but it is the only thing standing between civilization and total global anarchy.
As we wrap up this masterclass, I want to leave you, the listener, the final provocative thought to mull over as you organize your notes and prepare for your exams.
We started today by noting that traditional international law was built by sovereign states, exclusively for sovereign states. It was a private club. But as we see the modern explosion of universal jurisdiction, as human rights treaties aggressively pierce the veil of domestic affairs, and as multinational corporations wield more economic power than dozens of countries combined, we have to ask a difficult existential question.
What's the question?
Are we witnessing the slow, agonizing death of absolute state sovereignty? Will the international law of tomorrow eventually bypass the concept of the state entirely to deal directly and forcefully with a global citizenry?
Think about that as you review the material. Thank you for joining us for this extensive deep dive into the fascinating world of public international law. We wish you the absolute best of luck on your exam prep. Keep questioning the invisible borders around you.